Are you struggling to pass your real estate exam? Well, I review questions, national and state questions, for you to prepare to pass your exam. So these are practice exams from the blue book that I've been using and have permission to use. So let me share that screen. So this is the book that we're using, and I'm continuing consecutively every week. And you can watch the prior sessions. I think I've done 3 or 4 weeks already, starting with the national real estate questions and then the Texas state questions. So Texas state questions will be on the second part of this video or of this session, webinar, whatever we want to call it, okay? So we're continuing today with question, pardon me, that's not the one. We're doing national questions. Hold on. We're doing test number 2. Okay, so this test or this section has to do with encumbrances, liens, titles, and transfer and recording and leases. So get prepared for this. If you bought the book, you can follow along. And so this is on page, let's see here. So the questions are on page 247, and then the answers, which I don't want you to look at, is on page 471. All right, so let's get started here. Okay, let me see if I can make myself a little bit smaller. Nope. All right, so encumbrances, liens, titles, transfers, and recording leases. So this is for national real estate exam. And type your answer in the chat, and I can help you if for some reason you get that question incorrect. And just bear with me as I adjust the screen, since I am doing it directly from the book, which I have permission to use. Yeah, I don't want to have anybody come up, copyright. So I do have permission. All right, number 1. Which of the following describes an encumbrance? What is an encumbrance? Okay, that is vocabulary. So liens is a vocabulary, titles, transfer, recording, leases. These are all vocabulary for you to learn and understand. Don't memorize them because you'll forget them. If you forget them after the exam, hey, that's okay. You can always go back and Google them and research them. So which of the following best describes an encumbrance? A third party's right to encroach upon a property without the permission of the property owner. B, a third party's right to claim the sale proceeds of a property that has been mortgaged or as collateral for a loan. 3, a third party's interest in a real property that limits the interest of the freehold property owner. Or 4, another's right to acquire a freehold interest in a property against the property owner's wishes. So what is an encumbrance? And you can type your answer in the chat, and then I can discuss it with you. So the answer here is a third party's interest in the real property that limits the interest of the freehold property owner. So when you're the 100% owner, you have all the bundle of rights of freehold. Okay, no, A is not. And so I will go over that. So again, third party's interest in a real property, right? Real property is the land and everything above it, on the surface, on the air, or underground. And it limits the interest of the freehold. So if you have a loan on it, a lien on it, or a fence comes into your property, or a building, okay, so that is interfering with the property. That's an encumbrance, is an interest in and right to real property that limits a legal interest, the owner's freehold interest. In effect, an encumbrance is another's right to use or take possession of a legal owner's property or to prevent the legal owner from enjoying the full bundle of rights of the estate. So somebody else could put a lien on it. You piss somebody off as a landlord, okay? And they go to the court and put a lien on it, or you owe them money, didn't pay for it, or you have a loan on it, that's a lien on it, that becomes an encumbrance. Now, someone answered a third party's right to encroach upon a property without the permission of the property owner. That would be like a squatter. No, that is not it. They don't have a right to go on. An encumbrance is something that is attached to that property and limits the freehold interest, all the bundle of rights. So the answer here is 2A, a third party's interest in real property that limits the interest of the freehold property owner. But thank you for participating. And yes, always type the question number and the letter answer. Number 2, which of the following is true of easements in general? What is an easement in general? That's a vocabulary. A, they involve the property that contains the easement and a non-owning party. B, they apply to a whole property, not to any specific portion of the property. C, they only involve the legal owner of the property. D, they may require a specific use, but cannot prohibit one. So an easement in general. The answer here is 2. They involve the property that contains the easement and a non-owning party. The non-owning party could be considered the dominant party. You have a survey of the easement, and it's in order to transfer with the property, it needs to be recorded. If it's not recorded, then when a property is sold, that easement is deleted, it erases. So let's say you have a driveway easement because you have a property and the joint neighbor can't access their home without the use of your driveway. So you have the right of way, you have the control of that easement. However, the neighbor is a dominant party and has use of that easement driveway. So they get to both maintain that easement. And the owner of the property cannot remove that easement if it is recorded, nor prevent them from using the driveway. It could be a well easement. It could be a septic easement. There are many different types of easements. So an easement is an interest in real property that gives the holder the right to use portions of the legal owner's real property in a defined way. Or you can also have a utility company easement. Easements rights may apply to a property's surface, subsurface, underneath, or air surface. But the affected area must be defined. An easement may be affirmative, allowing a use such as a right-of-way, or negative, prohibiting a use, or such as an airspace easement that prohibits the property owner from obstructing another ocean's view. So if you have an easement for the airspace above you, that means you can't build. So the dominant party has that easement, right? Which limits the owner from building a high rise on their property and will prevent the view of the ocean or mountains or something like that. So remember, we own the land surface, the air surface, and below the surface. Number 3. So I hope you've been studying your vocabulary, because without the vocabulary, it's going to be difficult to pass the exam. It's crucial that you study vocabulary every day, not to memorize them, because you won't know, you won't remember them all, and you won't end up using a lot of them. Okay, number 3. Dang it, another day of internet issues. I may have to change our class to 6 p.m. instead of 5 p.m. because of these interruptions. I don't know if you heard that. I may have to change the class to 6 p.m. instead of 5 p.m. It's certain days out of the month I have a 6 o'clock Zoom call by an investor, and so that's why I made it at 5. Okay, number 3. Mr. King wants to offer 100 acres of his property for sale. How many acres? 100 acres. Since the property is landlocked, what is landlocked? He will have to put it in a driveway to the road that will run across his remaining property. What kind of easement will he have to grant? A, easement in gross. B, a commercial easement. C, a personal easement, or an easement appurtenant. So, hey, easement in gross, vocabulary, commercial easement, vocabulary, personal easement, vocabulary, easement, pertinent. These are all vocabularies. Hi, my news channel. You have a YouTube channel. That's awesome. So, yes, correct. I was already going to put 2.4. Yes, 2.3 is an appurtenant easement, an easement appurtenant. It's attached to the property. And that owner has to give them right of way without any limitations, especially if it is recorded. So Mr. King says what? He's offering 100 acres of his property for sale. Landlocked. When it's landlocked, means there's no access to that land. It could be behind him or to the side, but there's no way to get to that landlocked property without going through Mr. King's land. Since the property is landlocked, we will have to put in a driveway to the road that will run across his remaining property. It could be on the side of it, and so it doesn't impact the center of his property. So this is an easement appurtenant, easement attached to his property. He becomes the servient party, Mr. King, and the other party is the dominant party. If you're not familiar with those, again, review your vocabulary. Okay, I've been researching other methods to show you these questions. All right, number 4. If property alpha has a court-ordered easement across property beta, in order for alpha to have access to a public road, the easement is okay, so what is this here? Property alpha has a court-ordered easement across property beta. So alpha needs access to that easement on property of beta. So in order for alpha to access this property to a public road, the easement is what type? An easement by prescription. B, personal easement, easement by necessity, or easement in gross. The answer here is easement by necessity. So alpha has a need to cross the other property. So he has court-ordered easement across somebody else. Why? Because he has a necessity to get to that property. So alpha to have access to a public road on beta's property. Okay, so you said easement by prescription. That's a different type of easement. So easement by necessity is an easement appurtenant, like it was on number 3. Granted by a court of law. Instead of granted by the owner, which would be an easement appurtenant, this is granted by the law, by the court. And so it is an easement by necessity. So the court of law to a property owner, because a circumstance of necessity Most commonly, the need to access a property. Since property cannot be legally landlocked, okay? Look up landlocked. Or without legal access to a public thoroughfare, everybody has to have access to a public road. Or without legal access to a public thoroughfare, a court will grant an owner of a landlocked property an easement by necessity over an adjoining property that has access to a thoroughfare. So the owner that maybe sold the land, or this particular person, Alpha, had purchased a piece of land and didn't have access, then, and maybe the beta didn't want to automatically give him access, then Alpha had to go to court. And since everyone has to have court to public road or public access, they were granted by the law. So the difference, easement appurtenant, done by the owner and the adjoining property. Easement by necessity, it is provided, approved by the court. That's the difference between those two. So the correct answer here is C. Very good. Thank you for participating. This is the way you get to practice. This is what these are. Practice exams from very good book. Number 5, an encroachment. What is an encroachment? We've just been talking a little bit about that. It's an easement that has not been recorded on the title of the burdened property. What is burdened property? What is title? What is recorded? B, an unauthorized physical intrusion of one property into another. C, a right granted by a property owner to the owner of an adjoining property. What is an adjoining property? To build a structure that protrudes across the property boundary. D, a structure that does not comply with a zoning ordinance. So what is an encroachment? So the answer here, an encroachment, is B, an unauthorized physical intrusion of one property into another. A storage shed, a fence, anything else that could be going into the original owner's property. So that creates a problem for the owner whenever they have to sell it. And this can create battles between neighbors. You'd be amazed at fencing. They said, oh, the prior owner let me put the fence there. Well, the new owner says, well, I'm now the new owner. And I'm saying, you have to move that fence. You're encroaching on my property. Oh, and then starts a battle. If the other person, felt that when he was given the right to put the fence there by the prior owner, feels he still has that right. He or she still has that right. And that's so if an easement is not recorded or an encroachment is not approved, then it has to be removed. Number 6, a court might grant an easement by prescription. Okay, we just had one question on that. If a town needs to dig a trench across the owner's property to install a sewer line to a neighboring property and the owner refuses permission. B, a property owner sells the front half of the lot and wants to continue using the driveway to cross the rear of the lot. C, a trespasser has been using an owner's property for a certain period of time with the owner's knowledge, but without permission. D, a property owner wants to prevent the owner of an adjoining property from building an improvement that blocks their view. So what do you think the answer is here? For 2.6. So a court might grant an easement by prescription if, okay, remember the prior question had to do with, a need. So the answer here is C. A trespasser has been using, Yes, a trespasser has been using an owner's property for a certain period of time with the owner's knowledge, but without permission. So the court might be doing that because that trespasser has the need to use it. So let's see the other one. So it says here, if someone uses another property as an easement without permission for statutory right, so that can be called, gosh, I just lost the vocabulary word. A court order may give the use of the easement right of prescription, regardless of the owner's desires. For a prescriptive easement order to be granted, the following circumstances must be true. The use has been occurring without permission or license. The owner knows or is presumed to have known of the use, and the use has been generally uninterrupted over the statutory prescription period. Sometimes that adverse possession, right? So they have possession of an easement because they've been using it. The owner never stopped them from using it, even though they were aware. And it has to be consecutive for a certain number of years, and it's different for every state. And actually, somebody that is like a squatter on a property could actually take over that piece of land if they've been maintaining it and maybe paying some taxes. That's adverse possession. So that's another vocabulary. Number 7, the purpose of a deed restriction. What is a deed restriction? Is to enable an owner to specify A, the form of ownership in which a property may be held. B, how long a property must be used before it can be legally transferred. C, what group of people are legally excluded from future ownership of a property. Or D, how a property may be used and what improvements may be built on it. So what is the purpose of a deed restriction? Builders use this when they're doing a development. So new subdivisions will have something like this. The answer here is D, how a property may be used and what improvements may be built on it. So a deed restriction is limitations that a builder or developer puts in their subdivision. Let's say they want all 5,000 square foot homes, and that has 2 stories, brick outside, sidewalk, 2-car garage, okay, and driveway. So they want all the homes to look like that, minimum that size or larger. That is a deed restriction. So once they build it, they create these restrictions, and these are above and beyond the zoning restrictions. Some people will go to the zoning department, planning department, and say, hey, why can't I do this? Well, the developer had to meet all the zoning or the city's restrictions and then added more. And these are for the types of home, size, shape, color, material. And then they will have a homeowners association to keep that managed. And then people have to pay a homeowners association dues. Okay, number 8. Melinda purchases a house and finds the lender in turn places a lien on Melinda's title. So what is a finance, house finance? What is a lien? And the lien in this mortgage transaction is, the lien in this mortgage transaction is what? A, evidence of debt incurred by a property owner. B, a promissory note granted by a property owner as security for a debt. C, the creditor's claim against the property and collateral security for the loan. D, the document required to clear clouded title. So what is the answer for 2.8? The answer here is C, the creditor's claim, which is the lender, against the property as collateral security for the loan. So Melinda, got defaulted on that loan and had issues paying. So the lender, depending on what state they're in, has a right to foreclose on that property or put an additional lien. Now, this can be when they first purchased the property, not necessarily being late on it. So whenever an individual buys a home, they have a loan, that lender is going to put a lien. So it is a vendor's lien that will be also on the deed. So that lien stays on the deed as the lender's name until that loan is paid off, or the loan is paid off when the property is resold. It cannot be transferred without the permission of the lender. Now, there are investors that do buy property without, that's another scenario, okay? Buying property subject to the current loan. All right, so the first comment I made that she was late, no, that's not it. This is when you're purchasing a property and you got a mortgage, then that lender is putting a lien on the property as collateral security on that loan so that Melinda continues paying the loan. All right. We're going into number 9. All right, number 9. Let's see if I can make it a little bit larger here. Number 9, in a lien theory state, well, that's not as large as I wanted it to. In a lien theory state, what kind of interest does a mortgage lender have in the lien property? So there are 2 different types of states, lien theory and title states. So in a lien theory state, what kind of interest does a mortgage lender have in the lien property? A, possessory interest. B, tenancy by mortgage interest. C, legal interest in a pro rata share of the property. Or D, an equitable interest. Type your answer in the chat. So the answer here is D. They have an equitable interest. A liener generally has an equitable interest in the property when it is a lien theory state, but not legal ownership. The exception is a mortgage lien or a property in the title theory state. In these states, the mortgage transaction conveys legal title to the lender, who holds it until the mortgage obligations are satisfied. During the mortgage loan period, the borrower has equitable title to the property. Okay, so in a lien theory state, it's an equitable interest that the borrower has. No, I'm sorry. What kind of interest does a mortgage lender have? They have an equitable interest, okay? So look up in your vocabulary the difference between lien theory state, equitable title state, and find out what type of state yours is, whether it's lien theory or title. And it depends on, and what the condition is who keeps the title of that property or ownership of that property. Number 10, how is a lien terminated? So how do you terminate a lien, a mortgage lien, or some other type of lien? A, payment of the debt that is the subject of the lien and recording of the satisfaction. B, transfer of the property that has the lien. C, recording of another lien that is superior. Or D, death of the lienor or lienee. Remember OR or EE? So what is the answer here for number 10? How is a lien terminated? The answer here is D. I'm sorry. What question are we on? I'm sorry. Eliminate that. Delete comment. Okay. How to terminate the lien is by paying the debt off, which is subject to the lien, and recording of satisfaction. So that is A. Now, a lien terminates on payment of the debt, or whenever, you know, a property is sold, then the buyer that buys that has a loan, and that loan pays it off. Payment of the debt and recording of the appropriate satisfaction documents. So they do need to be recorded. So whenever you buy a property or someone that you are helping is buying a property, make sure they go check that it is recorded by the title company. Payment of the debt and recording of the appropriate satisfaction documents ordinarily terminate a lien. So there is a lien release when that loan is paid off. If a default occurs, a suit for judgment or foreclosure enforces the lien. These actions force a sale of the property. And every state has different foreclosure laws. So whatever state you're in, right now there are foreclosures or short sales that are happening. Not a lot yet, however, good. So all right, so let's see. Someone answered A, got it right. Is that Oscar? I think it's Oscar, right? O-R. All right, number 11. A judge rules in favor of the creditor in a court proceeding and places a judgment lien against all of the debtor's assets, including the real property. This is an example of A or N. A, voluntary junior lien. B, involuntary superior lien. C, involuntary specific lien, or D, involuntary general lien. All right, Oscar, great. Good to have you here. So when the judge rules in favor of the creditor in a court proceeding and places a judgment lien against all the debtor's assets, not just the real property, what kind of a lien is this? The answer here is D. It's an involuntary general lien. General is a broad, kind of like a general in the military. So think of all debtors' assets, okay, that it's large. It covers everything. It's a general lien, and it's involuntary because that person didn't volunteer to have that lien on all their assets. They did something to where, you know, they had a bad time. They're getting everything foreclosed, you know, filed bankruptcy, you know, or lost everything. And they owe a lot of different people or companies money. Therefore, a lien is put on all their assets and all the properties that they own. And for investors, a lot of them will put multiple asset protection, multiple levels of asset protection. However, you know, because then a lot of research has to be done by an attorney in order to find out who the actual owner is of properties and of assets. Number 12, a real estate tax lien, a federal income tax lien, a judgment lien, and a mortgage lien are recorded against a property. Which lien will be paid first when the property is sold? Remember, you have a priority of liens. Lien 1, 2, 3, and 4. So here they have one, let's see, real estate tax lien, income tax lien, federal income tax, judgment lien, mortgage lien. So which one gets paid first? Which one has priority? The answer here is A. It is a real estate tax lien. So real estate has property taxes. That becomes the primary lien on any property. Second will be the primary loan. and then others. So the category of superior or senior liens ranks above the category of inferior or junior liens, meaning that superior lien receives first payment from the proceeds of a foreclosure. The superior category includes liens for real estate tax, special assessments, and inheritance tax. Other liens include income tax liens, mortgage liens, judgment liens, or inferior liens, mechanic liens, all types of liens. Child support, spousal support, those are all liens. No, but yeah, you said, Oscar, you said mortgage lien. No, mortgage lien is the second. So real estate tax lien is primary, and then the lender, and then income tax. So go back and check the order of liens on a property. What is the order? What has superior, junior liens, superior liens, junior liens, and there's so many that can happen. I have done foreclosures or negotiated with lenders where a property had multiple liens. And we go through, a lot of times those lien holders will take less than what is originally owed. If they put that lien on a property so that they can get some money whenever that property is sold. Okay, number 13. Did I put the answer? Yes. Okay. A lien holder can change a lien priority of a judge junior lien by agreeing to what? Who's the lien holder? What's a lien priority? What's a junior lien? A, change the date of recording. B, lower the amount of the claim. C, cancel the lien. Or D, subordinate the lien. So what's the answer for number 13? So the question was, a lien holder can change the lien priority of a junior lien by agreeing to D, subordinate the lien. So a lien holder, a liener, okay, whoever is has the lien on somebody else, can change the priority of a junior lien by voluntarily agreeing to subordinate or lower the lien's position in the hierarchy. So they can lower their position in the lien hierarchy, the priority. This change is often necessary when working with a mortgage lender who will not originate a mortgage loan unless it's senior to all other junior liens on the property. The lender may require the borrower to obtain agreements from other lien holder to subordinate their liens to the new mortgage. That was 13, right? Yeah. A lot to know and understand in all these concepts. So if you're not familiar or understanding, lien positions, go back to the section that you studied having to do with liens, mortgages, loans. Number 14. Which of the following accurately describes the act of foreclosure? A court-ordered acceleration of a loan payment. What is court-ordered? What is acceleration? B, the final step in a bankruptcy filing. What is a bankruptcy filing? C, a proceeding to enforce a lien by forcing the sale or transfer of a secured property. Or D, a proceeding to take equitable title to a property that was liened as a security for a mortgage loan. So what is the answer for number 14? Which of the following accurately describes the act of foreclosure? Type your answer in the chat. The answer here is C, a proceeding to enforce a lien by forcing the sale or transfer of a secured property. So the mortgage holder or the mortgagor, that's the person that was given a loan. The mortgagee is the lender, the bank. or an investor that loans money, like a hard money lender. The mortgagor is the person that has to pay that loan. So the mortgagee, the lien holder, will enforce, okay, a foreclosure on the mortgagor, which is a proceeding. They have to go to, well, in certain states, they have to be approved by the court. In other states, it's included in the deed of trust, the process to go through a foreclosure, and that is done by the trustee. So in this case, a proceeding to enforce a lien by forcing the sale or transfer of secure property, right? Because the mortgage company already had the lien on that property. Now they have to enforce it because the person did not pay. The mortgager was not paying. So the lender wants to get that property back, get it sold. Preferably, they might want to do a short sale, which if there is a short sale, it's when the loan is greater than the current market value and they approve receiving less money than what is owed. If you can't do a short sale, then they will foreclose and it goes to the court steps. Of course, they do notify the owners, and the owners have to make sure that they respond. Number 15, a property is secured by a mortgage that does not contain a power of sale clause. To foreclose, the lien holder will have to do what? A, file a deficiency suit. B, file a foreclosure suit. C, file a suit to quiet title. Or D, obtain a quitclaim deed. You also want to learn what are the different types of deeds in the order and which has the most protection. Okay, so here it said a property is secured by a mortgage, right? So that mortgage is a lien on the power, but it does not have a power of sale clause, a due on sale clause, or power to sell the property. To foreclose, the lien holder will have to file a foreclosure lawsuit. So this is where they do have to go to the court and get permission by the court because they don't have a deed of trust, which then describes the process or the steps that are taken in order to foreclose on a defaulted loan. So the answer here was B. So certain states have to go to court, and those are there are foreclosure states, and I'm trying to remember the terms. Not foreclosure. So two different types of foreclosures. One, you have to get permission from the court, and another one, just follow the instructions that are in the deed of trust. All right, so that was the last question that we were reviewing today for national questions. Anyone have a question on what we just reviewed? If not, we will go then to the state questions. I did the wrong thing here. I meant to do this one. All right, so today we are reviewing national questions and then Texas state questions. So the first 15 questions we just did were state questions. The next series are going to be Texas only, Texas state questions. In Texas, we have 2 exams. We have a national exam, and then we have a Texas state exam. And today we're starting with we're continuing on test number 13, question 11. And again, for those that maybe just came in, this is the book that we are using. Although it says Texas Real Estate License, it includes the national portion. And all the books that this author publishes, Stephen Metling and his son and 2 others, has a national section and has their state-specific section. And of course, they review all the different sections that you have studied. You know, in Texas, we have 6 courses, 180 hours. They review all that material in the beginning of the books. And I love these books because they do have that, and they're not the only ones. Okay. However, I have their permission. And what I like about this is they have really good answers, not just the letter answer, but really good answers with explanation for each of the questions. All right. So, oh, tell you which book, right, but you can't see, can you? Bear with me. Sorry about that. Let me show you the book again by sharing my screen. All right. So the book that we're using here, I explained it. Okay. So they don't have one for every single state, but they do have at least, I don't know, 28 or 30 different states, and they're continuing to add more states. So we are on do with Texas licensing regulations. And so these questions are on page 395 or 391. And then the answers are on page 574. And it'd be great if you have the book and you can follow my videos, okay? All the sessions that we do, you can follow the book with this book. And if you decide to buy the book, use the link. I would greatly appreciate it if you use the link in my video, and I will get a commission or a short amount of money from Amazon. All right, number 11. Again, this is Texas state questions, and we are dealing with Texas licensing and regulations. So bear with me for a moment while I set my other section here. What did I say? 1311. Yes. Okay. I have 3 different screens. Okay. Monitors. All right. Number 1311. Let me type on here, Texas state questions. Okay, so nobody had any questions, so I'm continuing on. Which of the following constitutes practicing law without a license? And remember, we are not attorneys. We are realtors. Not realtors, but we are realtors. R-E-A, real, and then T-O-R, realtor. I used to say realtor, and so do many others, but the real word is realtor. So which of the following constitute practicing law without a license? A licensee completing lease blanks in a lease that was written by an attorney. B, an agent completing a promulgated contract. C, a licensee completing the blanks in a contract prepared by a principal. Or D, a licensee altering a lease clause at the direction of a principal. What do you think the correct answer is here? Remember, we are not attorneys. We do, oops. I was going to almost give you the answer. So the answer is D, a licensee altering a lease clause at the direction of a principal. We cannot alter any legal documents. Never, never, never. The only individual that can do that is a real estate attorney. Or, you know, an attorney that is helping with legal documents, preferably a real estate attorney. So the alteration of a lease clause requires the creation of legal contract clause, which requires an attorney license. Licensees in Texas are essentially limited to form completions or promulgated contracts activity, whether a client's contract or an attorney's. So never, 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 never edit any contract, any legal document. Please keep yourself out of trouble. Always be honest, truthful, and transparent. The best way to be is honest. Number 12, which of the following best characterizes trust funds? What kind of funds? Trust funds. A tenant security deposit. B, a rent check paid to a landlord. C, an unearned fee charged to a tenant. Or D, any money held on behalf of another. So what are trust funds? So trust funds are any money held on behalf of another. So when money is delivered to a title company like earnest money, which is part of a contract, you have to put who is doing the closing, who's facilitating the closing. It can be a title company, an escrow officer, or an attorney acting as an escrow officer. There will be earnest money that is deposited with them and they put it in a trust. So that is any money held on behalf of another. They are holding money from the buyer, okay? Or an individual is holding money, okay, for a lessee. And it cannot be commingled. Do you know what commingled is? If not, go study your vocabulary. You're probably going to get tired of me saying vocabulary, vocabulary, vocabulary. But if you watch Prep Agent Joe Juder, he stresses that a lot. He's an excellent YouTube and tutor and has his own testing facility to also learn from. You do have state specific if you purchase from them. What number are we on? Number 13. When a home buyer gives a broker an earnest money deposit, what kind of money? Earnest money deposit that comes along with an accepted contract where both parties sign. The broker is bound to do what? A, return all funds upon requests. B, comply with fiduciary duties owed the seller. C, abide by the terms of the sales contract. Or D, immediately deliver the funds to the seller for depositing. Oh, some of those are big no-nos. So when we have a contract that's signed by two parties, right, the seller and the buyer, what do we follow? Well, we have fiduciary duties to abide by the terms of the contract, number C. So the home buyer gave the broker earnest money. When I first started in Oregon back in 2001, but then became full-time in 2005, because I was an engineer, so I kept going back to engineering jobs. Brokers used to hold the earnest money for the buyer. And once it was completely accepted between seller and buyer, then it was taken to the title company for closing, or an escrow company, or an attorney office. Yes, and back when I started, we didn't have MLS offices. We had books where we would look up all the properties that were for sale. We would get a book every week. It was so different. How times have changed. Number 14. A sales agent receives a security deposit on a lease. What is this sales agent's proper course of action? So a sales agent, a realtor, deposit the funds immediately in her trust account. B, deposit the funds within 3 business days of receipt of the deposit. C, deposit the funds in the operating account immediately. Or D, deliver the funds to the sales agent's broker or depositing, for depositing, pardon me. Okay, so far I have 14B. No, 14B is not correct, Oscar. Take another attempt. What am I typing here? That would be more for a sales contract. This is a lease. So with the lease, deliver the funds. The answer is D. Deliver the funds to the sales agent's broker for depositing. Sometimes we don't take cash. It's there's dishonest individuals out there in all areas. So sometimes we take a check and we have a make a copy of it and initial it that we received it, and we hold that until the seller signs it, because on a lease, the seller wants a deposit, right? So once the contract is signed between the buyer, the tenant, and the landlord, the lease, okay, then the lessee has to deliver the money. In our case, it goes directly to our broker. So the deposit gets delivered to the broker. The first month's rent gets delivered to the owner. So if we receive some money, then we deliver it to the broker. The lease threw me out. Yes, that's really easy. So it's really important to read the question, sometimes more than once. Obviously, you only have, I think you have 4 hours in the state of Texas to take the exams, and you get the national and the state, 2 separate exams. And you want to go through and answer all the questions that you know first. And typically, I've learned that skip the first 5 questions and then go to the others, because a lot of times we get the first 5 questions might be the most difficult, and we can always tag them to come back and do them. So it's typically recommended skip the first 5 questions and then do all the others that you know first, then come back to the beginning and answer all the ones that are flagged. You can flag them to come back to them. Sometimes a future question will help you better answer an initial question. So you want to go through all of them, do the ones you know first, and then go through the exam again, and then answer the best that you can on the left, on the questions that are left. Did I put the answer? Yes. And you want to read the question carefully. I mean, typically you have enough time, but I was a slow reader. When I took it in Oregon, I didn't finish, and I didn't pass the first time around, so I had to take it a second time. I also took it in Michigan, and I didn't pass, but then I left Michigan. I didn't need to retake it. In Texas, I only took it once. In Texas, I only had to take the state exam, because I had an Oregon license. So in Oregon, I took the national and the state. And when I came to Texas, the national is the same for all 50 states. I still have to take all the courses. So if you decide you want to practice in 2 different states because you move around or you visit multiple states, you have to take all the courses for those states. But once you take the national exam and you pass in one of the states, you only take the state-specific portion in the other state. Number 15, hopefully you understood that. As a newly licensed broker, you receive a buyer's earnest money deposit on Tuesday morning. When is your deadline for depositing this check into your trust account? So this is when licensed brokers are still taking in earnest money. So they received it. The earnest money was, you received buyer's earnest money deposit on Tuesday. When is the deadline for depositing this check into the trust account? A, Wednesday morning. B, Wednesday night. C, Thursday night. D, Friday night. So what is the correct answer here? So this is earnest money deposit received by the broker, not by the title company. So what number are we on? 13. And don't get confused with depositing according to the contract to a title company versus to a broker. The answer here is Thursday. So they received it on Tuesday. They have 2 days to deposit it into the trust account of the broker. See if the answer says anything. Yeah, so trust funds must be deposited by the end of the second working day following receipt of the funds. And this is for a broker's trust account. When it comes to a Texas contract, the contract says within 3 business days. Because, of course, title companies are not open on weekends. However, realtors and lenders are, right? So, because that's when most people don't work. To work with sellers more so than buyers, but I do work with buyers. Not as many, but I do work with buyers. The way to grow in this business of real estate is to represent sellers. We can represent multiple sellers and do marketing for all of them and stay in touch with them weekly. However, when it comes because we're not out driving around and showing property. When we're working with buyers, we can only work with a few buyers because we're going to spend hours showing property, driving to properties to show them. It takes a lot more work. Requires more time of our physical time than it does for marketing and listing a property for sale. Number 16, the Jordans and the Couriers have jointly directed the broker Michael in writing to pay out the earnest money deposit to the courier's son. Okay, so the Jordans and the Couriers have jointly directed, so both buyer and seller agree. Directed the broker, Michael, in writing, to pay out the earnest money deposit to the courier's son, Stephen, despite the fact that this action is not stated in a permitted disbursement in the sales contract. Because in a sales contract, the money goes to the title company. Michael refused to disburse. Which of the following is correct? A, Michael must disburse the funds as directed. B, Michael must follow the provision of the sales contract and refuse the directive. C, the principals have made an improper request and the matter must go to arbitration. Or D, the matter must be remanded to the registry of a court for settlement. Oh my gosh, go to the court? Really? Okay, so pay attention here. Both buyers and sellers in writing directed broker Michael to release the earnest money deposit to the couriers, who are the sellers, but to the courier's son. Despite that this action is not stated as a permitted disbursement in the sales contract, but both buyer and seller agree. So what is the answer here? This can be a challenging question and must read it carefully. The answer here is A. Michael must disburse the funds as directed. Why? Because it was put in writing and an agreement and signed by both the seller and the buyers. Great. Good job, Oscar. Number 17. A home seller makes a legitimate written demand for a buyer's earnest money deposit following an undisputed buyer default. In this case, the broker does what? Okay, so what happens here? A home seller, so the seller has an offer from a buyer, and the money is with the title company. And they did a written demand for a buyer's earnest money deposit following what kind of a buyer dispute? An undisputed buyer default. That means the buyer doesn't disagree. They don't dispute it. In this case, the broker must disburse the funds within 7 days of the demand. B, must disburse the requested funds within 30 days. C, must notify the buyer in advance of an imminent withdrawal from the trust account. Or D, must return all funds less any earnest commission and marketing costs. So this is a demand letter. So whenever a transaction doesn't close and somebody defaults, the seller or the buyer, and typically it's the buyer, and both parties have to sign to release any earnest money. If they don't both sign, there's a termination. Well, there's a release of earnest money that has to be signed by both parties. So if it isn't signed by the buyer, let's say the buyer left or something, then the sellers will request the title companies on a written letter, very brief, demanding those funds from the buyer, or requesting those funds be released to them. So both parties get notified. If one party does not dispute it, in this case, the buyer was in default and they did not dispute, then the seller gets the earnest money within 30 days. Letter B. So must disburse the requested funds within 30 days. I had this happen once where both parties believed that they should keep the money, and there was a demand letter written. And both parties said, no, it belongs to me. It belongs to me. So what happens to that earnest money? It stays with the title company for a certain time in their trust fund, and then it gets released to the state. So nobody gets that money. I don't think they really discuss it much, and it does happen. And so it's a good thing to know, because both parties have to sign a release of earnest money. The buyer defaulted, right? They didn't close by the deadline, or they didn't perform. Then you would think, okay, the seller gets to have that money. However, the title company legally cannot release it, even though the contract may state such, right? Because the buyer defaulted. Both parties have to sign, or a demand letter is written. Number 18. Dang it. I'm trying to get it there. All right, number 18. Did I write the answer? Yes. And if you have typed the wrong answer, please let me know, okay? I make mistakes. We're all human. We all make mistakes. Number 18, trust fund documentation must be maintained by the broker for what period of time? Again, remember, these are Texas questions, if anybody just came on. A, 1 year. B, 2 years. 3 years. D, 4 years. So how many years trust fund documentation must be maintained by a broker? Type your answer in the chat. Going once, going twice, gone. The answer is D, 4 years. Brokers must maintain those records for 4 years. Number 19, a buyer and seller have a serious disagreement about the payment for repairing a defective water filtration system in the subject property. What is the subject property? That's the property that is being sold or is in topic, okay, of concern. The buyer gives up and demands the deposit back. The seller disagrees, claims the buyer has defaulted, and demands the earnest money as liquidated damages. What should the broker do? Okay, again, so the question, buyer and seller disagree, serious disagreement about payment for repairing a defective water filtration system in the subject property, in the property that they have a contract to sell and buy. The buyer gives up and demands the deposit back because the seller is not repairing. So what happens here? A, follow the instructions of the broker's attorney. B, pay the trust money into the registry of a court and let the court resolve the issue. C, submit the dispute to the local board of realtors for arbitration. Or D, conform to the terms of the sales contract. Man, so many things about going to the court. Man, the court should be our last option. However, this is what kind of a disagreement? A serious disagreement about the payment. So nobody wants to give in here. And the buyer demands the deposit and the seller doesn't agree. So now they're in conflict. And if it can't be resolved between the brokers, the realtors, the clients, then it goes to what? It can go to arbitration or mediation and then arbitration. So the answer here is B. Pay the trust money into the registry of a court and let the court resolve the issue. We can only do so much. We cannot force anything. The title can't force anything there either. So the courts are the proper source for trust funds disbursement resolution when the parties cannot resolve the matter and there has been a demand letter, right? And the broker's attorney should not be brought into conflict with the principals and their counsel. Finally, many disputes go well beyond the letter of the sales contract. Therefore, it cannot always be relied upon to handle all dispute characteristics. So this is not the case where a buyer defaulted, okay? This is a disagreement concerning a repair for a defective water filtration. So did I type the answer yet? Yes, okay. Number 20. A licensee wants to sell a subdivision for lot she owns. What does the licensee have to do that is any different from a non-licensee selling the lot? Okay, so licensees have more education than the average buyer and seller, so we have more knowledge and have to follow different steps, right? So A, the licensee must provide current market value documentation. B, the licensee may not list the property with her broker. C, the licensee must tell the buyer that she is licensed as soon as they meet one another. D, the licensee must disclose her license status in writing before signing any contract. So what do we think the answer, what do you think the answer here for number 20, 1320 is? So the answer here is D. The licensee must disclose her license status in writing before signing any contract. So whenever the contract is filled, it'll state in there that the licensee is a realtor. That must be stated in that the owner of that property is a licensed realtor, is a licensed agent, okay? And so that the other party is totally aware of that. Yes, it can be a tricky one. So the answer on here elaborates and says, salespersons are not allowed to market property in which they have an interest without written disclosure. It must always be disclosed. This is to convey that the license is an ostensible professional in a business and has a knowledge of transactions that is greater than an unlicensed consumer. The licensee may list her property, her own firm, and does not need to provide overstand in price or value justifications. So whenever a licensee is representing themselves, they're selling their own property, one, it must be disclosed whenever somebody calls and advertise on an advertisement. And before a contract is, when the contract is written, okay, if the buyer has a realtor, then the other realtor is going to put on there that the seller is a licensed realtor, a licensed agent in the certain state. It could be from another state, but they are licensed. So they have more knowledge than the average consumer. And that licensee that owns it cannot be giving comparables and advice or anything like that. One, because they don't represent them and they are the owner of the property. So typically another person, another realtor or broker will represent the buyer. Sometimes the buyer goes directly with the seller, and that's okay. Just doing all the fiduciary duties and disclosures and putting everything that's legally required in a contract. Most brokers prefer that owners of property use another realtor because not all realtors have sufficient experience to do that. I've been an investor, so I have bought and sold property multiple times, and people have bought directly from me while I was licensed. So there are provisions, disclosures that must be done for selling personal property. So for an individual or realtor that has experience, some brokers will allow it. Okay, so today that's the last question for state. So we did questions 11 through 20. So we did 10 state questions and we did 15 national questions. And I greatly appreciate you attending, and I hope that this helps you. And I can't stress enough, study your vocabulary every day if you can. So to prepare for any exam, create a schedule for yourself. Be consistent in studying daily or however often you're going to put it on a calendar. Make a commitment. This is a serious event that you're going to be taking, and that's taking an examination. So you want to be consistent, have a schedule, have a quiet place, inform your family not to disturb you while you are studying, or go to a public place. Study on your phone or on a computer. Sometimes you can study with calming music or a calming diffuser to calm you down, because yes, it does get stressful to some, because multiple choice, like for me, were scary. Yes, multiple choice exams were scary to me. I was better at math. I love math. So when I was preparing for mine, I studied every single day for hours. And I took so many practice exams that I would take them several times. If I got a 70, I would do it again. If I got an 80, I would do it again. I would keep retaking the same exam until I got 100 score. Why? Because typically the actual state and national exam are more difficult, and they have questions that we will never know that we studied. They want us to think, okay, and be resourceful. So that's why if you don't know an answer, take the best guess. Sometimes they say, look at what the answer of the prior two questions were. If they were D's, a lot of times the third question will have a D answer. Not always the case, but if you're creating a strategy for questions that you may not know, there are approaches. You can take, you can Google or on YouTube how to study for multiple choice tests, and they'll give you ideas of how to go about it. I have some, I think, on my Facebook group that, and on my Facebook group, Oscar, you have to reapply because I require the email and to answer some questions. I think I already have your email, so I may approve you, but I don't approve everybody that requests. But the best thing is to come in here. But there are some free resources on my Facebook Agent Prep private group that you can check under files, okay, extra material. And there's the night before the exam and other tips and tricks for preparing for an exam. But study every day. All right, guys. So next session will be Wednesday. I'm doing these consecutively with the real estate book, the blue book. A lot of students call it the blue book. And so I'll show it again just so that you're prepared. on the book. So this is the book. It's a blue book, and many, many states have it. This is the latest edition, 4th edition that was released in October. And so I keep upgrading and getting the latest edition whenever they release one. And it's perfect for now because of rules that change and contracts that changed after the NR this year, after the lawsuits with NAR, National Association of Realtors. So if no further questions, or if no questions at all, thank you for attending. Study every day. Study the prior videos on YouTube that are under the 2025 playlist. And I have old ones on there. I have lots of vocabulary. So guys, ladies and gentlemen, please study that vocabulary. I wish you the best in your preparation and that you pass that exam. Until next time, catch you later. Wild Lily Handy coming to you from San Antonio, Texas with YouTube Agent Prep. Love y'all.